Hi, my name's Clare Murray, and I'm managing partner of specialist employment and partnership law firm CM Murray. And today we're going to be talking all things law firm merger. I'm absolutely delighted to have my partner Zulon Begum with me. Zulon is a law firm merger specialist. She heads our non-contentious partnership practice. Most recently, she has been involved in advising Taylor Vinters in their partnership combination with Mishcon de Reya. So in our 10-minute chat on law firm mergers, we're going to talk about, firstly, why do firms typically merge? How do they plan for it effectively? Does money typically change hands? What if some of the partners don't agree? And finally, how can you make a success of a law firm merger? So that is a lot of ground to cover, Zulon, in a very short period of time. So let's kick off with, why do firms typically merge?
Well, there can be a combination of many different factors, but typically what I see is normally because the firm wants to expand into different areas, whether it's different practice areas, geographies, or it might be that they want to improve the size of their firm, their bench strength in certain areas, and improve their financial position, as well as growing in a kind of growth market. There may be other issues involved, particularly with smaller firms around succession planning and financial difficulties, especially lots of firms coming out of this pandemic might have experienced some financial difficulties over the last couple of years.
What are the few biggest things that firms can do to prepare for a merger?
It's always good to have a good strategy in place as to why you want to merge, whether it is for those kind of growth ambitions that you want to realize. And then from that, it kind of then leads on to identifying the right merger partners to fulfill that strategic goal that you've got in mind. And if you're one of those reactive firms who are maybe experiencing succession planning issues or experiencing financial difficulties, then obviously your kind of your strategy is pretty much to save the firm as far as possible, and finding the right merger partner as soon as possible is always a good thing in those circumstances.
Would firms considering a merger be recommended to look at their constitution before going into that, or is it something that just gets carried along as part of the process in your experience?
Yeah, so in the planning stage, I would say the kind of three other things I would include in that is obviously having a really good communication strategy in place, whether that's with your partners, because getting partner buy-in is absolutely crucial in any merger process, as well as with your clients and your people in general, and the world at large, because you will have seen the merger leaks all over the place in the press, and that can sometimes kind of derail the whole process. So having that good communication strategy in place is really key. The second thing will be, of course, as part of that, getting that partner buy-in process, ensuring that you've actually teed it up in your constitution, understanding exactly what process needs to be followed and what approvals you need to gain in order to pass any potential merger. So if you have in your LLP agreement a requirement for unanimous consent or 90% consent of partners in order to effect a merger, that can be a real stumbling block. So you might want to address that beforehand. As part of that constitutional review process, you'd also want to look at what other kind of protections you have in place for the firm already, and whether you need to introduce some more. So whether you have good notice periods, the ability to keep people's money back, and restrictive covenants, because those kind of protections for the firm can become really important in merger discussions, because we often see where there are some disgruntled partners involved as part of the merger who are not happy with the direction of the firm or the proposed merger. They might want to leave and take clients and people with them. So in those circumstances, you need to ensure that the firm is properly protected. And the third part of preparing, I think, in this context would be to ensure you've done some element of due diligence on yourself as a firm. Because we often see some of the key things that become roadblocks to a potential merger are things like financial issues within your firm. So that might be very high PI costs because of an adverse claims history you've had. So maybe addressing that issue. There may be historic financial liabilities that again might not be attractive to a potential merger partner. So things like very high lease costs or historic annuity liabilities can become a problem. And often you see lease break clause timing being the crucial timing that for lots of firms look for merger opportunities.
So it's as much about, it's obviously you've got to know your strategy, you've got to know what powers you have and what authorities are required, but also you've kind of got to know yourself. And what about, so we often get the kind of, the show me the money kind of approach in law firm mergers, but how often is that? How common is it for money to exchange hands in a law firm merger situation?
If you asked me this question 10, 15 years ago, I would have probably said to you, Claire, that not very often. Usually you saw law firm mergers back then just being a combination of people and resources, and the value in that merger being the value that's created from the merged entity going forward. But now, with the advent of alternative business services and the diversification of the legal market, so now we've got the Big Four involved, we've got other accountancy firms, we've got listed firms, we've got firms that are backed by private equity, we've got more US firms coming in, and international firms coming into the market. So there's a big mix out there, and there are some entities out there with some firms with quite big war chests who are able to actually put real money on the table when in this sense kind of buying another firm. So you see listed firms like Knights who are constantly sweeping up lots of smaller firms in the market, and I assume money changes hand in that case, probably shares as well in the listed firm. One of the other things as part of doing your kind of own due diligence on yourself and reviewing your constitutional arrangements is kind of thinking in advance as to if there was money on the table for a merger, how would that be distributed between the partners? And one of the kind of perennial issues I often see in these circumstances is that a lot of law firm merger constitutional documents don't actually envisage the potential that the firm might make a capital profit from this type of transaction. And then when you're presented with this opportunity with real money presented to the partners, then it becomes quite difficult to have that conversation with your partners as to how that money should be divvied up. So actually thinking of that in advance of any money being in the horizon is actually a good idea. And kind of setting that out in your constitutional document is key.
What are the steps that firms can then take to really make a success of the merger? Because I mean, there are some really horrible statistics about how many of these law firm mergers actually fail, within 5 years. So what, in your experience, helps to make them really work?
Factoring that in, that ultimate goal of actually not just getting the merger over the line, but actually making it a long-term success going forward should be part of your planning process itself. So actually finding the right merger and party to start with is the key. Law firms are a collection of two bunches of people coming together, and culture is really key here, and finding that right cultural fit will help a long way in ensuring that the firm as a merged entity is successful going forward. But that's probably one of the most subjective things to understand. And having those key meetings with the right people and really getting a feel for what the firm culture is and whether they will fit together is absolutely really, really important. Connected with that is what kind of partner remuneration structure you have. So if you're a pure lockstep firm, you'll be very different culturally to a neat what you kill model. And obviously you've got a whole spectrum of firms that fall within those two kind of extremes. And lastly, the other thing I would say is ensuring that you have either in your merger document, your merger agreement itself, or in the post-combination partnership agreement that you put in place, strong protections for the firm. So often you'll see in post-merger firm constitutional documents a lock-in period for the partners for a certain period, so that partners are not allowed to retire within a certain window, so that can typically be between 3 to 5 years. And also ensuring, as I've mentioned before, having other protections in place and ensuring they're enforceable in your agreement, things like restricted covenants, waiting lounge provisions, which prevents more than a certain number of partners retiring in a certain period, so you don't have a mass exodus of a partnership. Maybe having good bad leaver provisions, and that can be really important, particularly if you've got money changing hands in this case. So it may be that you want to withhold some of that money as deferred consideration so that partners are incentivized to remain and work hard. And or if you don't have any money changing hands, you may want kind of deferral periods, longer deferral periods for bad leavers.
So if a firm's planning a merger, how long does a merger process typically take? And I guess what are the key things that might influence the timing?
It's kind of one of those questions that's like, how long is a piece of string? It may take you quite a long time because you're being very strategic about it. You're putting your strategy together, finding the right partner, and then going to implementation stage. And those kind of processes can actually take years. But on the other hand, you can be presented with an opportunity sometimes out of the blue, and then you have to move very quickly to implement that, to make the most of that opportunity that comes your way. But the kind of key things you need to think about when you're thinking about timing of a merger is kind of the third-party consents and the processes that you need to follow. So one of the key things for law firm mergers is obviously the SRA consent, and that can typically take up to 90 days. And we have regulatory expertise in-house that we can guide you through that process and kind of factor that into the timing. The other third-party consents typically are your banks, if you've got banking covenants, your landlord, if you're kind of carrying on any leases. And other kind of timing issues might be around 2P consultation process with your employees. And again, we can help with the employment side as well as the partnership side and the regulatory aspects as well of law firm mergers.
But for those people who just don't really fancy this new world and want to look at other options, I mean, where does this leave them?
It's partly down to the constitutional agreement, the partnership agreement, what that says, and also what the objective of that partner is. I guess the writing will be on the wall. If the merger is going ahead, the requisite majority have approved it, and it's kind of powering to a conclusion. You as an individual partner at that point need to make a decision as to what you want to do. It may be that you decide to give it a go and kind of go into the merged entity and see how it goes going forward, but you have to do that with your eyes wide open, because at that point, as I mentioned before, there may be more restrictions introduced into the new firm merged entities partnership agreement, so lock-in periods and all that. But the advantage for you as a partner, if there is consideration paid, that you can participate in that by being part of the merger. But if you decide that you don't want to join the merged firm, you also want to think about whether at that point you might still be entitled to some of the proceeds. And again, you need to kind of obtain advice as soon as possible as to your position, because as I said, a lot of law firm partnership agreement don't often kind of specify how capital profits in these circumstances will be distributed, and will any partners who leave just before the point of the merger be entitled to a share of those proceeds. The other things you as an individual also need to have a think about is obviously what the existing restrictions are on you, what notice period you need to serve as a partner, what restricted covenants you will be subject to as a departing partner, and being very careful, as obviously in these circumstances, as to what you do in terms of talking to any clients or other people in your firm about moving, because that can put you in a difficult position if you are subject to restrictions.
And these are matters that, I mean, there are a number of complex issues around it, including sometimes issues of 2P get thrown into the mix as well for consideration as to whether LLP members are covered by that. But I mean, ultimately, they tend to be matters of commercial negotiation in the individual circumstances. If you and your partners are interested in law firm merger issues, Zulon will be absolutely delighted to speak to you. We would love to speak with you, and contact details are at the end of this video. But in the meantime, I hope you've enjoyed it. Thank you again so much, Zulon, and hopefully see you soon in one of our next 10-minute talks. Take care, and thanks very much. Bye.
Bye.